Any written communication.
This meeting is being recorded.
Sorry, go ahead.
Any written communication submitted in advance of the meeting have already been provided to the Commission. For those who would like to make a comment, a call-in telephone number was provided on the agenda, which can be viewed online. The phone number and instructions will also be provided during the meeting. Staff, please call the roll.
Commissioner Gomez. He may be having audio issues. We'll come back to him. Commissioner Gooding.
Here.
Commissioner Patel.
Oh, he's off.
Here.
Commissioner Mackin.
Here.
Commissioner Sayasan.
Here.
And we'll return to Commissioner Gomez.
If Commissioner Gomez is calling in by phone, I don't know which phone number he is, so he could let me know so I can admit him, either in the chat or by text, but I think he is here.
Yeah, I think he shows on all our screens, but only as a name.
Oh, here he is. Okay.
I see him now. Commissioner Gomez.
He's got no mic showing.
Yeah, he's calling in, but there's two.
Okay.
I could let the two people in and ask them if they're Commissioner Gomez.
Maybe we can send them a text.
Yeah, I'll text him. Oh wait, I have his number. I think I know who. Okay, I think I know which one he is. Oh, now that person's calling. Sorry.
Commissioner Gomez, if you can hear us, can you raise your hand, please? I didn't see any indication from him that he acknowledged my request.
Yeah, Julia, he is telephone number 4148.
4148. That's not in the waiting room, so we'll work with him on connecting, but if you want to move on, we'll technically say he's absent.
Julia, are you looking at chat? There's a message there from him. I'm having audio issues, calling back in now. Says, please let Julia know what number you are using. That's from Cindy.
Okay, is this Commissioner Gomez?
Commissioner Gomez, can you hear us? If you can you please raise your hand?
I'm unable to unmute this person.
He says he can hear you, or he gave you a thumbs up anyways.
Okay, great.
And he's present, but we'll have to figure out what's going on.
Okay.
We could, it's up to the chair if you want to start the other part of the meeting, and we'll
hopefully we can figure it out.
Yeah.
Okay, adoption of the agenda. May I have a motion to adopt, please?
So moved.
Second?
Second.
All in favor? Oh, let's have a voice vote.
Commissioner Gomez, could you raise your hand, please?
Aye.
Okay.
He's with us, okay. Commissioner Gooding.
Aye.
Commissioner Mackin.
Aye.
Commissioner Patel.
Aye.
Commissioner Sayasan.
Aye. Motion passes. Next is a consent calendar. We have none. I'll move to oral communications. If there is any member of the public who wishes to address the Commission about an item not on tonight's agenda, please call or text within the next minute or two, I guess. Staff will dispose.
Last time, I think we agreed on 30 seconds, but we do actually have someone in the waiting room currently.
Okay.
But we'll set a timer for now for 30 seconds after this person comes in. So I'm going to admit them. Okay. Caller, you are in the meeting. You are muted. and I continue to be unable to unmute you. Okay. I really apologize. I'm not sure why I can't unmute. If there's any way you can unmute on your end, I'm going to ask for some tech support. And we'll keep the oral communications open until I can figure out how to let this person communicate.
Okay.
So apologies for that.
And while we're waiting, John, so we were sent some written communications, but it's in regards to the subject of tonight's public hearing, which we will, I guess, be continuing. Should I, address that now, or will that be just put with the packet for that hearing at a later date?
It will be put with the packet at the later date. When we get to that item, if you want to note who the comments are from, just for the record, you don't have to read them into the record, but if you just want to note who you have comments from, if that's your pleasure, you can do it then.
Okay.
So I have a question on that. Does that mean that those letters then become part of the packet that's distributed to everyone for the next time we hear that?
Yes.
Okay.
Okay, caller, are you unmuted?
I believe I am.
You are. Yes. Sorry about
okay.
that.
That's okay. This is Michelle Salmon, and I wanted to speak during oral communications, and I will also be speaking on the issue tonight. But during oral communications, I just wanted to talk to the Planning Commission for a second about 338 Kings Road. I know that it was overturned the appeal was accepted by the City Council. But I just really want to commend you for the really hard work that you did and acknowledge the fact that what they approved was not what was in front of you when you denied the application. I watched both meetings, and you did a remarkable job of really looking at everything and taking into account all of the issues. And I think because of your very diligent and hard work, that what is going forward will be a great deal better than it would have been without your diligence and your hard work. And I know that it was never about denying these people a right to have off-street parking. It was really about the safety issues and the trees and all of the things that play into this. And so I just really want to reinforce that how very much I personally appreciate the work that you do, and that the city of Brisbane and the people of Brisbane appreciate the work that you do, even when it doesn't always come to exactly the point that you wanted it to. So I just really want to thank you for your hard work. Okay. Thank
Michelle,
you.
Before you go, Michelle, I haven't heard back yet from my tech support. So since you called in and unmuted yourself, how did you actually unmute yourself, just so I can advise other callers?
I was trying to unmute myself, but I was on a different keypad, and so I had to go back to the screen where I dialed in and hit *6, and then I was unmuted.
*6. Okay. Thank you so much.
So
Sorry about that.
*6 does work, and I heard Julia saying, please hit *6 about a million times, but I was, somehow or another, I had a different keypad up on the screen from when I was texting. So
I see.
I'm sorry. Okay.
We apologize. Thanks for waiting.
Yeah, and I'll be calling back in. Okay? Thank you.
Thank you.
I do not have any other callers in the waiting room, so we can move on.
Okay. So now we'll turn to written communications. As I stated, we did receive 4 letters from neighbors of 130 Sierra Point Road, which was going to be the subject of our public hearing tonight. And those letters are from C. John Skier. He's a neighbor at 281 Humboldt Road. A letter from Helen Chan, a neighbor at 140 Sierra Point Road. A letter from Terry O'Connell, who resides on the same block. And a 4th letter from B.B. Lee and Kate Goka, who are at 126 Sierra Point Road. So I guess those will all be put in the packet for next time, and then we can address those in more detail at that time. Okay, so we'll turn to our hearing tonight. So I guess we just make a motion, John, to continue the hearing.
Madam Chair, I suggest you read the item.
Okay.
And I'll just, because again, it wasn't agendized for continuance, so the continuance request was received later. So. Okay.
So this was a public hearing which concerns 130 Sierra Point Road, use permit UP-1-20 and grading review EX-1-20. It's in an R1 residential district. The applicant is seeking a use permit to allow for non-conforming interior dimensions of an existing two-car garage and grading review for approximately 150 cubic yards of soil cut and export to accommodate a new 3,101 square foot single-family dwelling on a 5,000 square foot lot with a 33% slope. Wilson Yu is the applicant and owner.
And Madam Chairman, the staff did receive a request from the applicant to continue this matter, allow them the opportunity to reach out to some of their neighbors who expressed the concerns that were raised in the aforementioned correspondence. So we're recommending a continuance off calendar.
Okay, may I have a motion to continue?
Well, I have a question. I just want to know if there's anyone that wanted to make public comment on this, because it was an agendized issue, if there's anyone in the community that was waiting to make a comment.
Should we, okay, we can wait probably another 30 seconds, Julia, and ask if anybody does want to call in. I mean, I guess they'll have an opportunity when we pre-schedule, but, you know, in the off chance someone wants to speak right now.
I mean, I would defer to John in terms of procedure. I guess if they're discussing project changes, that might, you know, if the project that comes to the commission eventually is a little bit different maybe than what's currently proposed.
Mm-hmm.
Certainly, if anyone wants to speak, that's certainly the commission's prerogative. Since the applicant's not present, staff's not presenting a staff report, there won't be any sort of substantive discussion this evening. We won't be providing any responses, but if someone wants to speak, that's certainly the commission's prerogative, or if they can call back on when the matter is re-advertised and rescheduled, that's another option for them. No objection to you seeing if anybody wants to speak on the matter.
Okay, why don't we just give 30 seconds, Julia, and see if anybody wants to call in?
Okay. Okay, I don't have anyone waiting in the waiting room, so I don't know if you want to give some more time. I know Michelle had said she wanted to speak, but maybe
she
it's not
thought
the
it
case
was
anymore. Yeah, I don't have anyone in the waiting room.
Okay, then we'll just move on.
Okay.
Okay, the next item is items.
Well, wait, did you guys make a motion? I'm sorry. Did I miss it?
Oh, I'm sorry. Yes. So may I have a motion to continue?
So moved.
I make a motion. A second.
Okay, and let's do a voice vote on that.
Commissioner Gooding,
Aye.
Commissioner Gomez,
Aye.
Commissioner Mackin,
Aye.
Commissioner Patel,
Aye.
Commissioner Saison,
Aye. So the hearing is continued on that. We will go to items initiated by the Commission, and that concerns an ad hoc subcommittee report on draft grading ordinance. So we have Commissioners Snapkin and Patel who will, yes.
I'm so sorry. Through the chair, someone just popped in right when you were making your motion to the waiting room. Mm-hmm. I leave it to your discretion or John's discretion.
Sure. If they want to comment, sure, why not?
John, that's okay?
Yes, that's fine.
Okay. I will admit them. I believe it is Michelle, but let's see. Okay, caller, if you could press *6 to unmute yourself and then announce your name and share your comments. Go ahead.
Hi, this is Michelle Salmon again, and I did not hear the part earlier where you were going to continue this to a new meeting, but I do want to speak on this issue. I live at 123 Sierra Point Road, and I grew up on Sierra Point Road, this first block of Sierra Point. So I've lived at 94 Sierra Point Road, 1 Sierra Point Road, 89 Sierra Point Road, and 123 Sierra Point Road. Many of the houses on this street are older and do not have garages, including ours. And this property is this, sorry, hold on. Sorry, I need to mute the computer because there's a lag time. So this property at 130 Sierra Point Road is a 5,000 square foot lot with a small existing building that was built in 1929 and a really rickety 2-car garage that is on the property line. And they were asking for a parking variance. And I do not think that you should grant a parking variance on this. This property was sold in 2005 to some people who did do some internal remodeling and to make it a larger place to live because the house was in very bad shape. And the previous owner had done a lot of very weird things to the foundation. And then it was sold again in 2019. And I've seen the inside of the garage. It is not usable for cars. A car hasn't parked in that garage in at least 30 years. I know because I've lived on this street that long. And it's on the property line, and it really needs to be torn down and rebuilt. And we have granted so many parking variances. And on this street alone, I'll tell you, back years ago, Karen and Paul Lynch lived at 58 Sierra Point Road. 58 Sierra Point Road used to be can you hear me?
Mm-hmm. Yes.
Okay. You just all have funny looks on your face on the screen, so I don't know. But 58 Sierra Point Road was a very small house when it was built, and it was built long before I was born. And then one owner came, and he actually added a second bedroom and made it a little bit bigger. But then Karen and Paul Lynch bought the house and wanted to greatly enlarge the house. They more than doubled the size of the house. They went around and talked to all the property owners. They were such good citizens. They only had 2 cars. They didn't want to enlarge the garage. Oh, please, please, please let us have a variance. And so they got their variance. And they could more than doubled the size of the house. They had a 1-car garage. They modified the driveway so that it was so steep that you couldn't drive up the driveway. And they never, ever parked in that garage. Paul used it for his workshop. And they ended up with 4 cars, 2 people, 4 cars. They each had a company car and they each had a private car, and they parked all over the street. And this is on a street that already does not have enough parking because a lot of the older houses don't have parking. The house next door, they later bought, 64 Sierra Point Road. They don't own that now. It has one very small 1-car garage that is not used for a car. And 101 Sierra Point Road has no garage. It was built by my dad long before I was born. 89 Sierra Point Road used to have a dilapidated carport, but that's gone. 107 Sierra Point Road is a 4-plex and does not have a garage. It does have 2 off-street parking places. Our house at 123 Sierra Point Road which was started in 1929 and finished in 1932, does not have a garage that's usable. We do have a rickety carport that's not able to be parked in. Okay, across the street, there's a small house that has an off-street parking place but no garage because it was built also in the late 20s. 155 Sierra Point, no garage. 179 Sierra Point Road, very tiny house, no garage. Down at the corner, there's a tiny house that is built on a 25-foot lot that has a very small garage that's not used as a garage. This street has a parking problem. 2 doors down, there's a house that's on a 5,000 square foot lot, but they have a single parking garage that they don't park a car in, and they use the entire 50 feet of their lot for street parking and then still parking everybody else's places. So it is unconscionable to deny, to accept a variance on this without adequate parking and back from the street. I mean, already the the garage that exists there is not only on the property line with no setback, it is also right on the line of the city right away. And that's just not tenable. And when they first bought the property in 2005, they were allowed to build a small retaining wall with dirt, and that was supposed to be removed within 2 years. It never has been removed. It is still there. Okay. And
Michelle,
yeah.
sorry, I don't want to interrupt you, but can you try to wrap it up? I mean, we'd like to actually hear a lot of this when the applicant's back to us for a hearing. So, but yeah, if you can wrap it up now. Okay, thank you.
But I'm just saying, if you look at the history of everything and all the variances that have been granted, this is not one to grant. There is no extenuating circumstances here. So thanks very much. I'm sorry, to take up so much time, but thank you.
No problem. Okay, thank you. Okay.
No one else is in the waiting room. So.
No one else is in the waiting room. Okay. So we will on then to the ad hoc subcommittee on the draft grading ordinance. So Commissioner Mackin or Patel, either of you want to start us off on that?
Sandeep, do you want to talk or do you want me to talk?
I just before we talk, I just had some questions that came up for staff, and it had to do with the redlined version of the statute, and I was just confused. I'm trying to pull it up right now. Sorry. As to the dates when the redlining and the blue lining and all that happened. So I didn't know if we could get some clarity on that.
You're talking about what was attached to what went to the subcommittee in July?
So
I'm not sure what red line is that. Is that the,
sure?
Is that the
so when
version?
we the previous packet that we got, I think we're on page, I'll pull it up, 50 something. The actual statute is provided, and there's a bunch of corrections and red lines and.
Yeah, let me have to pull it up. I believe that was from the iteration that was from that process in 2012, 2013. Let me pull it up. That's what that was referencing.
Sorry, page.
Would you like me to put it on the screen as well? Would that be helpful or no?
I don't know if you can find it very readily. So it was a part of the last packet. Okay. Mm-hmm. Sure, if you have it, Julia, that would probably be fine.
Okay. Okay, sorry, which page, Commissioner Patel?
It's page 50 out of 98.
Okay.
And it says, if you, where it says red line version of draft grading ordinance changes to in the current municipal code recommended by staff and the planning commission are in red strike through deletions.
Mm-hmm.
So it says right there, recommendation from the September 16th, 2013 council meetings are in green. Recommendation from the council subcommittee are in blue. And it says planning commission are indicated red strike through deletions and red text additions. Do we know when that was? Was that after September 16th?
No, it was prior to the item going to the city council.
Okay.
That was part of what the planning commission recommendation was at that time.
Okay. That was the part I didn't understand. Colleen was saying that was the case, and I just didn't know that was true.
Okay.
Sorry, I just didn't know.
All right. Yeah. No, my apologies for wasn't clear.
And then the planning commission approved that in 2013 before the September 2013 version?
Yes, it may have been 2012. I don't have the data off the top of my head.
Okay. And then was there actually public debate or public input on the statute at that time?
Yes, there are public hearings at both the planning commission and city council.
Okay. So then it seems like a lot of what I was going to say is kind of gone by the wayside because it seems as though there was public hearing on this. My only questions really is when I was reviewing this, and this is what I'm saying to the commission in general, when you look at the definition section of this particular statute, from what it is currently, the city engineer definition has changed, which means that the director of public works or the city engineer of the city of Brisbane and his or her duly authorized designees or anyone they delegate would be making these decisions. So it was just a little bit weird to me because it seemed as though anybody could be making the grading decisions. Is that what was contemplated? Because the way I read that, the director of public works doesn't have to be an engineer. Just so happens that maybe he is one right now. Also, because of such a broad language, it could be actually anybody that makes that decision.
I'm not sure. Certainly the commission you can offer your comments. That's not my interpretation of the code. That it could be a non-registered engineer to serve that purpose, but
I'm sorry. I'm just okay. Just it says under such on page 53. If you look at page 53, where it says city engineer.
Yes. Uh-huh.
So when it says director of public works, I don't think that the job title for the director of public works they don't have to be an engineer. It could be someone that has like a public administration degree or anything else. Isn't that right?
No, I don't know. I'm not familiar with the job classification requirements.
Okay, well, I Googled it and it said, I Googled it, so that's not like the end all be all, but it said that to be a director of public works, you could have a degree in public administration and be a person that's the director of public works. It's also weird that the city engineer definition has the word city engineer in it, just because you're defining what city engineer is. So I don't know if that was done on purpose. Also, it's left really broadly open, and it says, and his or her duly authorized designees, which could be anybody, doesn't necessarily have to be an engineer. Also, once again, it's reiterated with the sentence that's included in there. The city engineer may delegate any of his or her duties under this chapter to his or her authorized agents or representatives. Once again, that leaves it open to anybody that's not an engineer. So I thought that was a little bit weird because based on the letter, it seemed as though based on the total packet, it seemed as though these decisions were to be made by an engineer or someone named named city engineer.
Well, yes. I mean, isn't that what state law says? So to the extent that that's what our ordinance says, it would be in contradiction with state law.
I don't know if the state law says that the city engineer has to make this decision.
It doesn't? I thought it did when I read it, that it has to be someone. No? John, can you confirm that? Because I thought it did. Isn't that what?
I believe it was in the business and professions codes.
Mm-hmm.
But again, my part of this particular ordinance is pretty limited in terms of I wasn't involved in the technical aspects of what the requirements are for the civil engineering side of this. So, I mean, certainly the commission, if you have concerns or questions, you can certainly raise them, but I'm probably not in a position to definitively get into the nuts and bolts of what the civil engineering and licensing requirements by the city engineer, the public works director, or what's required under the business and professions code requires.
So the business and professions code, I looked it up. Sorry, Pamela, I looked it up. It basically says that no one's allowed to practice engineering if you don't have a license to practice engineering. So no one's allowed to practice law if you don't have a license to practice law. Similarly, right? But when it's a little, I think when we're looking at this packet, it's a little bit weird because that language is in there that says, yeah, you're not supposed to practice engineering if you're not an engineer. Well, no one's practicing engineering. No one's giving recommendations from the planning commission on how an engineer should make the report or do their job or whatever. So that's why it was interesting to me that the definition of the city engineer wasn't more specific in the context of the package of being someone that was an engineer. And in fact, when you read about the appeals process with this statute, it says that someone that's not an engineer can hear the appeal if there is an appeal. So I don't think that the two are connected, or they're not connected in a way that makes sense. Those are some of the things that I noticed in terms of this statute. I also had a note. I had some other notes, but I don't want to take up all the time. Colleen, did you have stuff that you wanted to say?
No, if you want to continue, that's fine. I have things I can say, but if you wanted to keep going, I'm all right with that.
Yeah, and it seems as though what John is saying is, since I don't know, these seem like questions that have answers, but that we don't have the answers to now. I would like an opportunity, and I think this is the letter that we sent, that we'd like an opportunity to have a conversation about this statute, just so that we can actually all go through and understand exactly what each of the different sections were and how they all work together. I think is ultimately where we came down to.
Can I jump in now?
Yes.
Real quick. This kind of had a life of its own, and it took a turn because Sandeep and I spent really a lot of time on this. And we started out where, I think if you recall the last meeting, and you might have said, they were talking about sticking wooden signs in the ground to post permits, and suddenly now they're examining this whole thing. And one of the things, just in looking at the last packet that was given to us and reading through the draft ordinance, that Sandeep pointed out, which was really important, is that the largest effect of it overall is that you lose public hearings completely. And one of the things that jumped out at us, because we reviewed the 2013 guidelines just to get a sense of what the departure points were, is that the 2013 guidelines really put an emphasis on the role of the Planning Commission in evaluating plans to make sure they're not contrary to the general plan. So is that really something that you want to remove completely? And just, we have no problem with the city engineer reviewing engineering reports, but it also jumped out at us that the city attorney was talking about reviewing plans holistically in the context of the whole picture. Engineering plans, the public, testimony, staff reports, staff recommendations. And of course, the general plan is the overriding Bible for all of this. So we remove a public hearing. How does that get done? And when we're talking about grading ordinance, the type of grading applications that have come historically now to planning, they're fairly large projects. And I gave the example in the last meeting we had about, I asked how you would feel if suddenly at 8 a.m. you had a bunch of trucks rumbling up next door to you with earth movers and crews and backhoes and started digging into a hillside, and you didn't even have the courtesy, someone didn't have the courtesy to notify you, and that could happen. So we removed the public hearings. You could say, well, the permits are still going to be based on the facts and engineering reports, and that's all true and valid. And I have confidence our city engineer knows how to read an engineering report and make a ruling on it. But what it doesn't account for then is if you knew that a permit application was pending or being reviewed, and you had institutional historical knowledge, and say you have a couple neighbors that do, and you want to go get your own expert, you have no way to testify and put this out in the public. And I think that that's something that is so important. I think that became kind of one of the overriding themes that Sandeep and I had on writing these recommendations, that think about what will happen if that's gone. And go ahead.
No, sorry. Go ahead, Colleen. I didn't mean to cut you off. I apologize.
No, you didn't. No, it was fine. Go ahead. Seriously.
And just to build on what Colleen is saying, I think that when we last met, Doug, I know you weren't here for that meeting, but there was a general sense that we didn't actually have a role in determining whether a particular grading project was appropriate or not. And I think a lot of that was built on the experience from Kings Road. But when I was going through this particular statute, and like Pamela, you said, like, isn't that what they were saying? Like, we can't make those decisions; those are engineering decisions, right? Mm-hmm. But actually, when you read the statute really closely, they're not saying that we're not going to be making decisions on grading issues. In fact, in section 15.01.110, it's on page 59 of the packet. It specifically says that the Planning Commission is still going to be listening to, we're still going to be listening to grading, except it's only going to be for those cases where more than 250 cubic yards of material is removed from a particular project. And basically, all that this is doing is lowering the standard from 50 cubic yards to 250 for there to be a public hearing.
Madam Chairman, I need to clarify something here. Two things. One is that the language in red, this is language that was proposed in 2012 and 2013. That's not the language that was recommended by that's not the current language. So I just want to make it's real clear that that's not the language that's not the current proposal.
Right.
So wait, no, that's actually, we didn't understand that actually. So the current statute has what's crossed off in red in it. But what you're saying is that the version that is being proposed is the version that's before it that has no red lines in it?
Yes. That this version was provided informationally so people could tell the difference of what changed over time, but the clean version was the modified version. So I apologize if that wasn't clear.
So that's like really hard to do, because then what we need to do is actually look at the clean version and then look at what's in the red to actually see what's different, right?
Yes.
How do we do that?
Well, I mean, it basically relates to that provision, and I think it was outlined in that cover report as well, that spoke to particular provisions that were being changed. yeah, you'd have to do that. For example, the provisions that you're referring to, 1501-110, that's basically being, I believe, just stricken in its entirety.
I think if you refer to the memos that came from the city manager and the city attorney, they really highlight a lot of the language changes in the draft ordinance. And those were the things that we looked at carefully, because those two memos are the major recommendations for changes in procedure. And there's also a little bit of contradiction in the two different memos from the city manager and the city attorney. And one of the things Sandeep, you just kind of touched upon, is that grading permits would go to the city engineer, but some grading permits would still be coming to the commission, as so long as there's a design permit, use permit, or variance being considered. And that's where we found the city attorney saying that these should be looked at holistically. So it's not as if we totally disagree with some of the recommendations, but the public hearings are very important. We felt that that was something that was such a dramatic departure, because the public input, to remove that completely, I think there's going to be a problem. And the problem is you lose the input, where sometimes we've had things brought up at meetings about certain properties, like there's a gas line runs through there, there's a sewer line, that are not on any city records. And whether it becomes integral to approval or disapproval, they're still important, and the public learns from this, we learn from it, and you keep that transparency. And once you remove that transparency on large projects, I'm just very concerned about that. The second part that came in this was also about trees, and there's a lot of language in the 2013 version of the Planning Commission. And by the way, at the 2013 version, and John, you talked about that a little bit, there was another memo, and I don't have it in front of me here, but it was referencing those meetings, and it said that the public hearings at the council level took place over several meetings. So they really spent a lot of time looking at this. And I just think that these current revisions, there's language in the city attorney's memo about changes at the state level, but there's nothing outlining or detailing what those changes are. So we're just told that there's changes and this has to happen, and there's no information. So it becomes rather troubling and confusing to look at, because there's some contradictions, and we have very strong feelings that the council needs to look at this and not accept it verbatim. And the other part was trees. Trees has been an issue. Trees were mentioned in that 2013 draft a lot. Trees fall under the general plan. So separating trees by saying we have a tree ordinance, I think that's contrary to looking at a planning application holistically, which is what I would agree we should be doing. So,
and also the trees isn't the current tree statute basically say that it doesn't come, there's no public hearing on those either? Is that correct, Colleen?
There's no public hearing. And we're not talking about trees on private property. We're talking about trees on public property.
Public property.
That's a very important distinction. So we've provided two different draft recommendations for you. One's very, very short, and Sandeep, you can talk about that one, and the other one has a bit more detail, citing some specifics. You're free to express.
I can just say this: when Colleen, when this first came up, I just kept thinking about the King Street analysis that we did, and a little bit of it was frustrating because I don't think that there was clear guidelines as to like what we were supposed to do and what we're supposed to follow. And as I started digging more into this particular statute and then looking at the role of the Planning Commission, specifically in Municipal Code Section 2.24.010, it defines what our role is, but it basically just says to go to the government code to see what exactly our role is. And in the government code section, in section 65.103, that really talks about what we're supposed to be doing and how we're supposed to be doing it. One of the things that we're supposed to be doing is encouraging public conversation and discourse onto projects in our community. And the reason why I had a problem with this particular statute is it's actually stifling public comment on projects, which is what the government code says we should be doing. And staff may disagree with that. They may say that there's still an opportunity somehow for there to be public comment, but it's in this different forum. But I think that public comment in a public forum where there's noticed hearings is a little bit different than having an administrative public comment where other people aren't actually hearing and listening to what people in the public may have to say on a particular project. And so based on that, I thought it would be kind of important to do an analysis of the statute as a group, and then give our recommendations as to what we think a particular statute, what it should look like, and do the analysis ourselves as well.
Well, John,
and also, it's 8 years later, so things may have changed.
So to follow up on what Commissioner Patel said, John, so isn't it true the proposed ordinance would take away any opportunity for the public to comment on any grading issue, correct? They wouldn't even know if a neighbor was about to grade or check out permits on it or whatnot, correct? That's the proposal that's going to be before the city.
If the project is ministerial, that means it doesn't require any kind of planning reviews or planning permits or variances, like a building permit, right? Mm-hmm. You have a building permit and your house complies with the zoning code, and the grading is now required to allow for this home to be built. That is correct. That would be a ministerial process.
No matter the amount. Okay. So there would be no way. So, they couldn't, just forget about the public hearing. I mean, they couldn't even know to write the city engineer about anything they know about the property. They can submit any comments at all. So that's a really big departure from what the public is getting now when anything above 250 cubic yards comes before us in a public hearing.
Well, right now it's not even that. I think right now it's 250, and in certain neighborhoods it's above 50.
No, sorry, can I through the chair?
That's incorrect.
That's not right.
Commission's review kicks in at 250 cubic yards
of combined cut and fill, or 50 yards of export from any site.
So cut and fill 250, but if you take 50 yards off of a property, then we still get it. Right?
Correct. If there's so if it's a situation where there's cut and fill occurring and that cumulative total is 250 yards, you would see it. Or if there's no fill and they're just cutting and taking away, they can cut up to 49 yards and you won't see it.
That 50, you get to see it.
Mm-hmm.
Right. And I think that the issue also is like, what does that actually mean? Because I don't think people actually know what like 50 cubic yards is or whatever. But
yeah, most people don't go around thinking about volume of soil in that way.
So isn't it approximately a ton per cubic yard? Is that right, or is that wrong? I mean, if you're going to estimate,
I could consult the internet
of dry.
If you'd like me to confirm.
Okay. I think it's approximately like a ton. So each cubic yard is like a ton of dry soil. So it's like 50 tons to 250 tons is like what the statute's talking about.
I'm seeing a conversion that's 0.27 tons per cubic yard. Wait, let's see. Oh, say 1.5 tons is coming up. Yeah, I think in the interest of, I wouldn't want to just go off a Google search. If you want us to confirm that, then we definitely can with the properly licensed professional. But
So is it possible we could hear from some of the other commissioners? Because I'm really curious if you've had time to read what I assume was sent to you. If you had any comments.
Commissioner Gooding, do you have anything to add?
Very limited comment. I think what we're experiencing here is a kind of a tension between the Commission's role in funneling public comments through our lens of applying the general plan and the municipal code versus the planning staff's concern with being able to streamline this process and having experts talk to experts and arrive at a scientific decision that is objectively based. Those are both fine goals, but they kind of butt up against each other sometimes when you have people in the neighborhood that perceive an impact from a project on them that they feel they don't have an opportunity to weigh in on. My initial reading when I first saw the comments of Mr. Holstein and our general counsel is that I would have liked an opportunity to discuss that with them in one of our meetings to see if there's some way to sort of meld those two interests. Mr. Rausch's comments were helpful and informative, but kind of came down hard and fast in a way that I didn't really fully agree with or fully understand, perhaps. Mm-hmm. So my suggestion is to perhaps have the commission consider the opportunity to discuss that with the city attorney in an open meeting so we can figure out if there is sort of a middle ground or a third way here to get enough opportunity for public comment on projects that are impactful to the neighborhoods without having myself and Sandeep and Colleen and Kamala pretend to be engineers. We don't want to do that. That's not what we didn't sign up for that, and I wouldn't dare do that. But when we hear lots of public comment and concern about projects, we feel, or I do, I think, and maybe I speak for some of the rest of us, in a position where we are charged with hearing the comments, but not given any ability to really impact the decision. And if that's going to be the case, then I think we need real clear guidance from the council on exactly how they want to handle that, with their full knowledge that they're affecting people's hearing rights.
Thank you. Commissioner Patel?
So, Doug, when I was thinking about that same question, that same issue of we're not engineers, so how are we supposed to deal with like these engineering principles and whether these things fall into the general plan or not, and whether this is a feasible project? And ultimately, we're not. I think it's like when you're in court or when you're in trial and you have an expert witness. You listen. You have an expert witness, but you also give the other side an opportunity to perhaps do that analysis, look at the analysis of the expert witness, and if they want, maybe have someone else that they want do the analysis as well. And if there is a different decision, then you can say, well, maybe can planning potentially consider this and see if their decision's different or do they want to change the plan. But at least it gives that opportunity if a neighborhood is like, you know what, this doesn't make sense. I know this street. I know how steep this street is. This project isn't going to work, even though the engineering report, which doesn't come, I don't think, from the city. I think that the applicant provides the engineering reports that an analysis may be done. But at least it gives the neighbors an opportunity to be like, you know what, we want to do our own engineering and like present it as well and maybe have that considered. But that doesn't happen unless there's public notice and there's an opportunity And we're not making the decision. We're not deciding like to either do an engineering report or believe an engineering report, but we can definitely ask the city engineer to be like, hey, they did their own analysis. Have you considered it? Should you consider it? I don't know.
Right. Yeah, I agree with that. I mean, not to get too lawyerly about it, even in a court of law, once the experts testify, a jury, which is kind of like us in a sense, gets to decide whether to accept that or not.
Right.
Yeah, I mean, that's the kind of the buffer in the process between having it be an experts-only discussion and a public discussion. And I think that's what we're struggling with, is how to figure out how to meld those two things. I'd like to get some more input from both the city attorney or city attorney and the council on this, so that everybody knows what we're doing, which is that we're kind of changing or fine-tuning what we do and what they do, and have it all make sense and be transparent.
I agree. I think it's definitely important before we make this kind of major change. We want the public to be able to come in and give their input and have the city attorney there, and probably have also our city engineer there. Let's have a full discussion so that people know what's going on before we make this big change. Commissioner Mackin, you have something?
I'm kind of going to add what you were saying, is that I think one impression I got with this is that the city attorney and the city manager, in their seeing that there may be state law changes, because they reference that criteria to review a project, but then nothing is said in the ordinance about what those objective criteria are, which is strange that wouldn't be included. So it kind of looks like there was a rush to put together this draft. And this isn't something that should just be rushed through just to make a change. I think that obviously if in 2013 they had ideas and it still wasn't changed, there should be some concerted thought that goes through this. And the cutting out the public hearing just doesn't even make sense to me, that you would want to do that. And so I just would like to see that, as Doug said, that there's just a little bit more thought and maybe a little conversation about questions or concerns, so that that's taken into account before this is finalized.
John, you had something?
Oh, just a point of clarification. This the ordinance is scheduled for city council review next week. So whatever recommendations you want to make as a body, I'd suggest you'll want to do that this evening, if you want that provided to the city council.
Commissioner Gomez, did you have any comments on this?
Paulo, can you hear us?
No, we can't hear him.
Because you called into audio. Okay.
Am I coming through?
Mm-hmm.
All right, today's a fun tech day. So I've been listening attentively. Appreciate the other commissioners' comments here. I've been struggling with this really from just a foundational perspective of how do we not get this particular situation better clarified, just based upon best practices with how other cities operate, right? I think it was Commissioner Mackin that brought up that one of the more common best practices among the Bay Area, right, is having a more inclusive process, allowing for public input. And I think just from a broader perspective, right, I think the city of Brisbane wants to be a inclusive and thoughtful, civically engaged community, right? When we look at these projects, I think that's really what we're going after, is how do we facilitate that type of process, knowing that none of us are credentialed engineers, and we don't want to necessarily be making decisions that wouldn't be fully informed, right? And I think we also are expressing concerns about, we want to have some sort of cross-comparative analysis, right? And not just taking one particular subject matter expert over another if we've got a hotly contested project in a particular area of the community. And so I think we've got to come up with a model that does require for more, more inclusivity, more kind of collective dialogue, so that ultimately, when a property owner, like the way I'm looking at this is a property owner is looking to make an investment, and there are disagreements with the decisions that they're trying to make, right, due to one reason or another, right? And there's a lot, and I think we need to. I really think we need to figure out an overall approach that is going to, I think, address what the commissioners have put forward thus far, and what the community's been, has been echoing through their public comments and through their letters. And I think we need to. Otherwise, I feel like we're going to keep running into these contentious situations. And I'm hoping that I'm coming across as clear as I can right now.
Thank you, Commissioner Gomez. Commissioner Mackin?
Just one thing, just as an idea. I think also that if we faced a public hearing where there were a lot of residents and neighbors coming through, and maybe they had an expert and anecdotal evidence that ran contrary to whatever engineering studies had been done, and we're not trying to pull on engineering, that it seems like it might be a situation where we ask for a continuance and ask for the city engineer to render an opinion on what we heard, or to attend the continued meeting so that he's there to actually refute testimony or add his professional opinions. And I understand that staff is always trying to streamline things. I understand that a developer or property owner has a timeline, but I think we have to consider the good of Brisbane over the good of one person, one property owner. So sometimes that might be necessary. It's not like we have grading permits every month. It doesn't run that way. So we're not talking about bogging down projects going through, because there's not that many in a year. There's only so much property in Brisbane that you're going to be grading, right? So we're talking more about exceptions than the rule. We're not going to be slowing down all the projects that would normally be going before the Planning Commission. But I could foresee that as one solution, that we continue it and we ask the city attorney to either render opinion to the testimony and bring that back to us, or attend it personally.
Or at least address it.
Mm-hmm. Right. And that would satisfy the public, too. They'd have an answer. They'd have something. Right now, they have nothing. They come to us in an engineering opinion, and we say, we're not engineers.
So, John, you said that the City Council will be addressing this ordinance change next week. So is that final? Like, there's no possible chance they could continue that so that we can, delve into this further?
We can't hear you because your mic's off.
It's they can always continue it. It's advertised for public hearing and scheduled for a public hearing. But sure, they have the right to continue a matter if they're so inclined.
I mean, the city's in no rush. I guess what I'm asking is to have this change, so so that we can take our time a little bit with it.
It's going to be up to the council to decide how they view this.
So, just from our discussions, it seems that the commissioners would want more time to kind of look at this. Like, we wanted to be able to, I think Commissioner Gooding said, talk to the city attorney, invite the public to talk about this ordinance change. I mean, is that what we want? We want more time to look at this? Commissioner Mackin?
So the question, we've got two memos that the subcommittee wrote, and more or less they are making different points to the council to consider, so that upon receipt of a draft grading ordinance from staff that the council won't just say, okay, we need to vote on this. So we're asking them to please take a look at it. So the question that I think we also have to decide is whether either one of these memos satisfies trying to call the council's attention to our concerns, or whether the commissioners would like to approach it another way or a different type of memo.
No, I thought they were very helpful. I mean, we can just, Commissioner Gooding?
Yeah, I just want to make one comment. The longer of the two memos, which I thought was largely very on point, and I agree with presenting those issues to the council. But one of the points is just really technical, which is my reading of the draft ordinance is that if a grading permit decision by the city engineer is appealed, it is appealed to the city manager, but there is still a secondary further right of appeal to the full council.
Right.
And I didn't want the memo to sort of ignore that or believe that. It's not, the appeal doesn't end with the city manager. It does eventually go to the city council if it's appealed sort of secondarily, where there would be right of public hearing.
When we talked about that, Doug,
yeah,
the only problem is that there's no notice. Like when your neighbor gets a window permit, you don't get notice of a window permit. So the procedure for appealing is typically, if you get rejected as an applicant, then you'll appeal, then you can appeal again. But if your neighbor wants to take 50 years of dirt off their property, you're not going to know to appeal or to file a secondary appeal.
Because you've removed the public hearing, and it's all taken place just with the city engineer. That was one of the other reasons we kind of kept coming back to this problem with removing the public venue and the public's right to not only come to a meeting and speak, but also to even know that it's happening. Because you could go on the city website and you can look at projects, but does everyone know to do that? Or does everyone do that all the time? Whereas when there's a project, usually, and Julia, you can speak to that with sending the postcard and notices to neighbors, but on some of these projects, the neighbors are noticed.
So, current noticing practice, you want me to explain that again? So anything that goes to the Planning Commission is noticed by mail to property owners within 300 feet of the subject property. It's actually not a postcard, it's a regular letter size paper we put in an envelope. But that's the procedure currently. Anything that goes before you. Building permits, anything that's non-discretionary, doesn't go to you guys. Those are not noticed.
Right. And that was a concern that came up at the last meeting and I wanted to address, but I finally ended up, I said to Sandeep, it's irrelevant. If that's kind of beyond just grading permits, so let's deal with that as a separate issue sometime. But right now, this is the big issue, is this draft ordinance and the public's ability to have input.
So to Doug, your point, it's a due process right for people getting rejected, not a public comment right.
Understood. Yeah, I get that. Got it. Thank you. Thanks for clarifying. I would be comfortable with moving or voting to send the longer the two subcommittee report to the council for consideration, and I think that pretty adequately states our concerns.
Okay. Okay, I would agree with that. I think you guys put a lot of thought into this memo, so that would suffice. Anybody else? So do we agree on that, to submit this longer of the two memos to the City Council for their next meeting?
Do you need a vote?
I will move.
I don't think we need a vote, right? John?
I would recommend you vote, and then I'd also recommend we can work with the chair to actually get a signed basically a letter signed by I assume you want to sign by the chair, so authorize the chair to sign a letter, and staff can work with you on, I guess you can probably prepare that yourself, whatever will work with you on getting it forwarded on.
Okay, so let's have a motion. So we have can we have a motion to submit this 2-page memo to the City Council?
I will move to submit the longer of the 2 subcommittee memos to the City Council, subject to making it look pretty by staff and our chair.
Can I have a second?
I second.
Okay, let's do a voice vote.
Commissioner Gomez?
Aye.
Commissioner Gooding?
Aye.
Commissioner Mackin?
Aye.
Commissioner Patel?
Aye.
Commissioner Saison?
Aye. We have 5 ayes. Motion passes. Okay, next is items initiated by staff. Staff, what do you have for us?
Just a couple of things. One, it was already brought to your attention by a previous speaker that the appeal for the grading of 338 Kings was approved by the City Council on their last meeting. So that grading permit was ultimately approved. And then the other item I had was available on probably tomorrow on the city's website. The comment period on the high-speed rail EIR has come and gone, and the city has written a pretty substantial letter raising some pretty substantial concerns with that environmental impact report and some of the impacts on Brisbane resulting from the high-speed rail project. So if you're interested, that should probably be posted sometime tomorrow online. I think that's all I have.
Thank you.
Julia, am I missing anything?
So actually on the 338 Kings, the City Council's hearing on that appeal, I actually have a few prepared words that I would like to make on that. So I watched the City Council's hearing this past week regarding 338 Kings Road, in which the applicant's appeal was granted by a 4-1 vote. I want to say that I respect the Council's decision, and I hope that the project will end up being a successful one. I do, however, want to make sure that the record is clear on something. While some may disagree with the decision this commission reached, it was based solely on our consideration of the objective evidence before us. To those under the mistaken belief that the commission's decision was influenced by emotion or personal appeals, I want to be clear. It was not. To anyone in doubt, I would simply refer you to the hearings on this matter, which are publicly available. I will conclude with this. I have tremendous respect for the members of this commission. During the time that I have served with them, each has acted with professionalism, objectivity, a desire to serve the public good, and always with the law in mind. Every single person on this commission, and that includes the 3 attorneys presently serving, is committed to ensuring a full and fair process to all that come before us. And while we appreciate the passion expressed by members of our community, we do not let that cloud our judgment. Speaking personally, I have practiced law for over 20 years, filed countless legal briefs, and argued before the state and federal courts. It would run counter to what I do to make any decision as a planning commissioner without adhering to the facts and the law. And I have every confidence the same is true of my fellow commissioners. With that said, I want to assure the public and anyone who comes before this commission that they will always be given our full, fair, and objective consideration. Thank you. That is all I have to say. Is there anyone else who wants to make a statement on that? Okay, no one? Commissioner Mackin?
Thank you. I want to thank the chair for her comments. I think you verbalized a lot that was on my mind, so I'll speak from that. I too watched the City Council's meeting, and I found a lot of it distressing by the way the Planning Commission hearings were characterized. I think that was unfortunate. I hope I don't see that again. I too will echo the same, that I think very highly of my fellow commissioners and their integrity. And I do not believe that we sit in these seats with the weight of responsibility, ruling arbitrarily and emotionally on issues. I can assure you of that. This is a hard job, takes a lot of work. We take it seriously. Thank you.
Thank you, Commissioner Mackin. Anyone else? Okay. Since I don't have anything else on the agenda, may I have a motion to adjourn to the next regular meeting of September 24th, 2020?
So moved.
In a second?
Okay.
Can I have the voice vote?
Commissioner Gooding,
Aye.
Commissioner Gomez,
Aye.
Commissioner Mackin,
Aye.
Commissioner Patel,
Aye.
Commissioner Saison.
Aye. The meeting is adjourned. Thank you.
Thank you.